My Lord Chief Justice of the Republic of Papua New Guinea, my Lord President of the East African Court of Justice, Honorable Minister of ICT and Innovation, Honorable Minister of State for Justice, Honorable Prosecutor General, Honorable representatives of international organizations, dear participants, all protocols observed. It is an honor and privilege for me to be here to address you, to address experts and policy makers in ICT and court technologies, as well as colleagues from different institutions concerned with justice. I'm particularly pleased to see so many visitors participating in this conference from so many countries. Particularly pleased that my colleague, the Chief Justice of Papua New Guinea, was able to come all the way from South Pacific to attend this conference. Very welcome. I also see former colleagues from the Comesa Court of Justice. The registrar is here. I see the registrar of the East African Court of Justice and many others. So it's particularly pleasing that you all thought it was important to attend this conference. I'm sure we shall be able to exchange a lot of information on court technologies and share best practices. The area of case management and how it affects performance and development is very important to our justice sector, as both Mr. Rugege and the Minister of ICT and Innovation told us about it. But more importantly, I want just to emphasize that we always strive to improve efficiency, timeliness, and quality of justice, because these are some of the factors that attract investors and thus contribute to the development of the country, of any country. Confidence in the justice sector is one of the forefront attractions for investing in any country. In particular, the program shows that you'll be discussing the functioning of the integrated electronic case management system that we have, its advantages, its challenges, and its potential for further development. We are also going to hear how some countries have advanced in the area of court technology, and we can learn from them how to further improve our own systems. I see that we will be talking about the history of case management in Rwanda. It has been a long way with several trials, but you'll explain that we still have a long way to go. Before the reforms of 2004, we only had a handful of computers in higher courts and in other justice institutions. Recording of court proceedings was done by hand, and all documents were kept in folders and storage was poor, with the risk of damage or fire or loss of files, whether the loss was intended or unintended. Finding a particular file was very difficult, since it meant physically searching through huge volumes of files in archives. Today, with the ICMS, we boast electronic access to court processes. Without detaining you in the details which will be provided by our more IT survey presenters, litigants can now file electronically and follow progress of their cases at any time of day or night from anywhere in the world on most electronic devices. Different institutions in the justice chain can exchange documents in the system to make delivery of justice more efficient and transparent. The cost and time spent on cases has been considerably reduced. Even the process of writing judgments has been made easier, with most information like police reports, witness statements, pleadings, records of proceedings, all accessible to the judge in the system. As a result, processing time for cases has been considerably reduced. In addition, because litigants do not have to come to court and interact with court officials, the chances of corruption have been considerably reduced, almost eliminated. There is transparency because everything is available online. Of course, this has not come about without challenges, as you will be informed, largely to do with inadequacy of capacity, both financial for purchasing of suitable equipment as we expand our services, and also in terms of technical skills to meet the ever more sophisticated demands on our system, on our services. There was also the issue of fear of technology by users, judges, prosecutors, lawyers, and of course, members of the public who also access the system. They were initially intimidated by the idea of finding everything on the computer and processing all their documents in the system. It has taken quite a bit of training and sensitization to change mindsets. In general, however, we continue to progress in addressing these challenges. We look forward to future developments with ICMS, including hosting an advanced searchable database of our judgments in ICMS, which is currently hosted by a Canadian company through something called Decisia. We hope very soon that we shall have all that transferred into ICMS. A more transparent monitoring and evaluation mechanism of court staff will be soon included in ICMS. Enforcement of civil judgments, and also providing for easy interface with other e-government mechanisms, such as the National ID Agency for identification of suspects, the Land Registry for dealing with the land matters, land titles, and the Forensic Lab for forensic evidence. Apart from electronic case management, which you'll talk about a lot today and tomorrow, another court technology we are trying to improve is the use of video conferencing in order to reduce further the burden of litigants and witnesses traveling to court from far-flung areas, saving them money and time. With relation to prisoners or detainees, video conferencing cuts out the cost of transport and ensures a secure environment for court staff, prosecutors, and victims, with the suspect or prisoner remaining within the prison walls. Although we have a few video conferencing facilities available, they are not used as much as we would like because they are not available in all the courts and at correctional facilities. However, I know that the leadership in all the different institutions, justice institutions, are keen to fully implement video conferencing or virtual courts around the country, but are constrained by the cost of the necessary equipment. I'm hopeful that progressively we shall get there. As a future development, we can foresee the deployment of virtual courts whereby a litigant can conduct his or her case from her home or office via Skype or other facilitation, with the judge sitting somewhere in the courthouse, as is already being done in some countries. I also see on the program you have a discussion on the electronic bracelet for use by accused persons or use on accused persons released on bail to decongest prisons and detention centers. We fully support this initiative, especially in the context of the principle that an accused is presumed to be innocent until proved guilty, and that such as an accused should be prosecuted while free on bail unless there are compelling circumstances that require his detention. Another area of court technology still very far on the horizon is the use of artificial intelligence and machine learning in court services, including determining sentence in criminal cases or damages in civil cases, complete with a robot judge. I understand there is already a project of designing a robot judge to adjudicate small claims in Estonia. I hope there is a representative from Estonia who can tell you in more detail about this exciting project, and that could eliminate case backlogs, especially in simple commercial cases and other small claims. I understand also that artificial intelligence can be used to make judgments less biased than humans because they are less subjective. We know that artificial intelligence and blockchain technology are already being used in internet courts in China to resolve disputes relating mostly to e-commerce transactions, intellectual property infringements, online unfair competition, misuse of internet infringing personal or property rights of others, and administrative regulation of internet use. With evidence stored by use of blockchain technology, electronic signatures, and timestamps, case processing is much faster and reliable. But that is probably another age for us. But with the way technology quickly spreads around the world, we may still see the use of these technologies in our justice systems in the not too distant future. In conclusion, Rwanda has come from far since 1994 in rebuilding its institutions, including those in the justice sector, thanks largely to the country's prioritizing of the use of ICT in all public activities and ensuring that we have useful ICT ministers who are still able to think quickly and innovatively. We are likely to get there. The justice sector has been able to introduce some modest court technologies that have enhanced access to justice and efficiency in administration of justice. However, we acknowledge that by international modern standards, we still have a long way to go. But what we can say is that our appetite for digitizing justice processes is only limited by our means. We shall continue to strive to advance in that area. We thank Synergy International Systems through the Chief Executive present for their important contribution in achieving this level of IT development in the justice sector and hope to continue our collaboration. I also wish to thank development partners who have assisted us in this process. I also wish to thank you visiting participants for choosing to come to this conference in our country. We hope you'll enjoy your stay in the country, that you'll have very fruitful discussions that will benefit both yourselves and ourselves. Thank you very much for listening.